Good evening and welcome to the 2024 Blackstone Society Lecture. A particularly warm welcome to our law alumni returning to college this evening as part of our programme of anniversary events, to members of the faculty here in Oxford, and of course to our judges who are gracing us this evening. This is our 400th anniversary year, and I hope you'll agree it's fitting that we mark the 40th annual Blackstone Lecture this year. The origins of the lecture are in the mid-1970s, when a generous alumnus and benefactor of Pembroke, Reggie Graham, suggested the establishment of a distinguished series in law to be sponsored by the college. Today, the event is generously sponsored by Atkin Chambers and supported by our alumnus, Mr. Martin Bowdery, King's Counsel. We are very grateful to them all. Since the lecture's earliest days, audiences have every year enjoyed the distilled thoughts of the most distinguished legal minds of the late 20th and early 21st centuries. They are regularly published in the Law Quarterly Review and extracted into compendia of all of the lectures for historians to analyse over time. Today is no exception, and it gives me very great pleasure to introduce my former colleague and our guest speaker this evening, the Right Honourable Sir Geoffrey Voss. Sir Geoffrey is the present Master of the Rolls, the President of the Civil Division of the Court of Appeal, and Head of Civil Justice in England and Wales. He began his distinguished judicial career as a Deputy High Court Judge in 1999, and Sir Geoffrey has since held some really important posts. The ones that I would want to note are President of the European Network of Councils of the Judiciary, Lord Justice of Appeal, and most recently Chancellor of the High Court, until his appointment as Master of the Rolls in January 2021. He's also a member of the LawTech UK panel and Chairman of its UK Jurisdiction Task Force. Sir Geoffrey is highly regarded in the legal community for his expertise in commercial and chancery law, and it is our very great honour to welcome him to Pembroke this evening to speak to us on the subject, Are Rights Sufficiently Human in the Age of the Machine? Please join me in welcoming the Master of the Rolls.
Well, thank you, Ernest, for that very kind introduction and for inviting me to deliver this prestigious lecture. I'm not going to talk about the Blackstone Lecture, but I'm going to talk to my subject. Perhaps the most popular contemporary subjects for judicial articles and lectures are now artificial intelligence and climate change. And you will all know that I have not been backwards in coming forwards to make my contribution on the former, if not the latter, subject. And tonight, I want to take a step back from the usual arguments about whether AI can or should be used for various hitherto human tasks, about whether AI is likely to make lawyers or judges redundant, and whether either or both of public or private law need to be adjusted to reduce environmental damage caused by the continuing global use of fossil fuels. I want to ask, even if I cannot answer, a more fundamental question that should, I think, be concerning the modern-day legal community. And that question, put at its broadest, is whether the current international legal order, as it affects the rights of humans, is fit for purpose in the light of the changes and challenges of what I think we can properly now call the machine age. I was struck when speaking last week at an international conference on artificial intelligence at the Swiss Institute of Comparative Law by the different approaches that judges and lawyers from different parts of the world are taking to AI and to the changes to our legal landscape that it is causing. In essence, as it seems to me, most are more comfortable speaking about what is going on at an operational level rather than venturing to consider higher level principles. I'm going to try to explain what I mean. On the subject of AI, the Chinese speaker at this conference explained how Chinese judges are using AI in their decision-making and how that enables them to deal with their large volume of cases and to ensure that courts produce consistent judgments in comparable cases. There is obvious and appropriate awareness of the risks of hallucination and bias, but these problems are, in China, tackled rather than used as a reason for objecting to the deployment of capable new technologies. Conversely, the Francophone African speaker was far less sanguine. He was concerned that big tech companies and the Western world more generally neither understood nor appreciated the problems that AI is causing and will cause in African judicial systems. And he warned against recolonization resulting from an irresistible push towards using AI in a continent where there is less digital literacy, less internet coverage and power capacity, and endemic corruption, which makes AI tools a particular risk. The US judge thought that AI was a useful aid to lawyers and judges, but that it could never replace human decision-making in trial courts. He was extremely concerned about cyberfakes and the injustices potentially caused by their deployment in family and criminal cases. And to make his point, he posted online an avatar of himself, introducing the conference, speaking fluently in both French and German, when in reality he speaks neither. I was, however, particularly interested by the French administrative judge, who understood completely the problem that AI causes in government administration. He did not want to stop its use, recognizing that that was impossible, but he wanted it to be understood that the European and French regulations that say that automated decisions cannot be taken where they affect a person's legal rights are easily circumvented by a machine making the calculations and advising the human decision-maker as to what they need to decide. He recognized something very important, namely that as machines become more and more capable, economic imperatives will prevent human decision-makers from questioning the products of artificial intelligence. There will simply not be the time or the money to allow each of perhaps thousands or millions of administrative decisions concerning pensions, benefits, immigration, just as examples, to be checked by a human. The regulation that says decisions must be taken by humans can be satisfied by the human signing off on a machine-prepared schedule of many decisions. So those perspectives covered a good part of the world, albeit excluding much of the global south and India. What they demonstrated to me is that we need to be careful to ensure that we do not sleepwalk into usages of extremely capable AI that change what humans do and how they do it for good without our ever having embarked on a debate about the fundamental rights of those humans in an age of AI and climate change. So let me then make some introductory remarks about climate change, because the problems are related. First, the rights of humans are indeed being asserted in relation to climate protection. And I can point, and you will all be aware of, the recent decision of the Grand Chamber of the European Court of Human Rights in Verein Klimasensorien Schweiz versus Switzerland, where it was held that Article 8 could be construed as providing certain environmental protection rights against the state. And likewise, in the recent case of Miele Defensie and Royal Dutch Shell in the Hague Court of Appeal, where it was explained that the citizen claimants had not established that Shell had a social standard of care to reduce its emissions by 45% or any other precise amount, but that court did acknowledge an obligation on Shell owed to citizens to limit emissions. Now, human rights have always been rights that vest in individuals against groups of people and states. Historically, business was generally subservient to the state. But what we see now is that the rights of humans are being asserted in the environmental field against both states and international corporations. Moreover, even if a single small state such as Switzerland were forced to reduce its emissions to zero, that would not necessarily solve the world's climate change problem. And this too seems to me to indicate that we may need to take another look at the rights that humans ought to have against both states and big business for the coming generations. I'm not sure there's really any legal thinking going on about the adequacy of the legal protections for the rights of humans in the light of the dramatic effects of more frequent heat waves and floods affecting every part of the world, and certainly the global south. So to summarize this introduction, I want to examine in this lecture whether it is right to say that AI and climate change are creating completely new situations that necessitate a rethink about the fundamental rights of humans. The last time such a rethink occurred was after the Second World War, which led to the drafting and ratification of the European Convention on Human Rights and Fundamental Freedoms. The question is whether the changes to the current legal order are such as to merit revisiting that convention and possibly others. I'm not suggesting that even if such a process were desirable, it would be easy to achieve in the current pretty precarious global political situation. But that's not really the point. If the international legal community were to think that the fundamental rights of humans needed to be reformulated in the light of these changes, then the debate would need to begin many years, I think, before a satisfactory outcome could ever be expected to be achieved. So I'm going to address first whether the current legal and regulatory approach to automated decision-making and the use of AI is really fit for purpose. And then I'm going to address whether the current legal and regulatory approach to environmental protection is really fit for purpose. And then I will come to ask whether, if not, what can or should be done to remedy those lacunae. So let me start with the question of whether the current legal and regulatory approach to AI is fit for purpose. Now, as it seems to me, there is or will soon be a spectrum of hitherto human tasks and decisions that machines will be able to take for us or help us to undertake. And that spectrum starts at the, as I see it, left-hand extreme, with broadly mechanical decisions like those about the amount of a pension or the benefits that you might receive, or actually, maybe more surprisingly to some of you, the calculation of personal injury damages and loss of earnings. It may be that humans are, or at least will become, fairly relaxed about those kinds of decisions being taken by machines, because the algorithms will be reasonably transparent. The use of machines will undoubtedly save a vast amount of time and money, and an appeal to a human judge, if the machine gets the decision wrong, would probably add to the human confidence in using AI in such areas. Now, more complex advice or decision-making lies in the middle of my spectrum. We are told by big tech companies that the situation is likely soon to be reached whereby AIs will be able to give legal advice very quickly and cheaply. It seems inevitable that such advice will be available in circumstances in which a lawyer would take hours or days to do the same thing, or even to check the accuracy of what the AI has done. The same problem applies to judges. If the AI will be able in future to write a judgment in minutes, even if the human judge is required by regulations to take the final decision, how is the judge to check if the AI's advice about the outcome and written judgment of the machine are correct without doing work that may take that human costly days or even weeks? And what will happen in this or any other field if the human cannot check the answers given by the machine? I would suggest that the human decision maker may find themselves obliged to accept what the AI, or maybe in some cases two AIs, are telling them are the answers. And in the legal sector, it seems unlikely that clients will want to pay for their lawyer to spend days checking an AI's legal view once they've established the reasonable reliability of the machine. And it's perhaps equally unlikely in that situation that litigating parties will want to wait months for a human judicial decision when a machine-assisted one can be taken for little money almost immediately. At the other end of the spectrum, I see it for some reason as the right-hand end, are cases that are peculiarly human, and they really are at the far end of the spectrum. And let's consider what they might be. First, the question of whether a child should be removed from its parents. The question of whether a life support machine should be switched off. The question of whether a murder should be treated less seriously as a result of provocation, causing severe emotional distress. Sentencing questions that arise where emotional mitigation is promulgated to the court. Now, most would probably say now that it is inconceivable that our societies would accept such decisions being made, or perhaps even being assisted by a machine. They depend on human empathy, which is something machines do not have, and which at the moment at least, machines cannot easily be trained even to replicate. So against that background of the spectrum from left to right of decision-making, I think there are three factors that should determine where in this spectrum of decisions it may be acceptable to use AI, either to advise or decide. First, human confidence in the technology, something I've already alluded to. Secondly, the pressures created by the higher cost of humans making decisions instead of machines. And thirdly, the question of ethics and fundamental rights. So let me quickly address each of those in turn. First, confidence in technology. We know that AI is already used very extensively by public and private entities. Apple, Google, Facebook, Amazon, OpenAI use it all day long to assist everybody and everyday tasks performed by all of us all the time. Governments already use AI to calculate your pensions, your benefits, your taxes, and many more things that individual citizens need and want. Ordinary people are often not even aware of the many algorithms that are in use to affect their lives. It may be, though, and this is possibly contentious, that they do not actually care. Humans seem generally to have a measure of confidence in the algorithms that are used in social media and even by government departments. They have a level of confidence, perhaps not complete confidence, that they will generally be treated fairly. And they believe that if not, they'll have the right to bring a claim before an independent court or a judge in their home jurisdiction. But ordinary citizens probably do not yet have such a level of confidence in machines deciding matters at the right end of my spectrum that turn essentially on human empathy. So what about the economic pressure to use AI? It's very easy for techno-skeptics, and I meet a lot of them, to say that economics will never affect our ability as humans to decide what machines should do and what they should not do. In fact, the harsh realities of economic power make that a far more difficult thing to say in practice. The big tech companies seek to reassure us that we will always have a choice, that machines will only be assisting us, and the final decisions will always be made by humans. That's the principle underlying the EU's AI Act and even the GDPR. But as I've already said, I doubt whether such regulation is, or certainly in the future, will be effective. First, even now, with the routine uses of AI that I've mentioned, there really is only modest pushback. Secondly, AI will be relatively cheap at the point of use, even if its consumption of power is totally alarming. So once an AI can read the lawyer's case papers, retrieve the relevant legal materials, and advise as to the answers, the lawyers, and perhaps even the judges, may find it hard to maintain that the same work needs to be done again or even checked by humans with all the expenditure of time and money that would involve. In short, once the AI is good enough, the human advisor or decision maker may be left, as I say, with no choice but to accept on economic grounds the solution proposed by the AI, because that human will not have the resources to challenge it. So I come to ethics and fundamental rights, because if that is right, it seems to me that our society has a growing ethical problem. Generally, most humans would probably prefer to decide what is suitable to be decided by a machine and what ought still, despite the AI's undoubted capability, to be decided by a human. And I say that even in the machine age. I cannot say what decisions are in which category, but I doubt that any of us would want all decisions, even those involving human empathy at the far end of my spectrum, to be made by a machine. And if that were to happen, there would arguably be an existential challenge to our humanity and to the democratic rights of our citizens. And the law is really all about how we relate to one another. It's not an end in itself. So the problem is how we decide, as technology grows exponentially in capability, what decisions must still be taken by humans, and how we stop the inevitable pathway towards humans formally taking those decisions, but being forced by economic pressures, in fact, to accept the advice or suggestions of ever more capable machines. And this ethical problem is said by some to be easily resolved by regulation. And I should say at once, I do not agree. But let me say a word about the role of regulation. There are a number of relevant existing regulations that attempt to stop automated decision-making. The French judge last week referred to Article 47 of the French Data Protection Law of the 6th of January 1978, of which I was not previously aware, and seems to have been the prescient origin of Article 22 of the GDPR. And it provides that a data subject has the right not to be subject to a decision based solely on automated processing of personal data, which produces legal effects concerning him or significantly affects him. And that's pretty much the same as Article 22 of the GDPR and of the UK GDPR, with which you will all no doubt be familiar, which gives data subjects the right not to be subject to a decision based solely on automated processing, which produces legal effects on them. And you'll be aware of the CJEU's decision in the Schufa Holding case, which indicates, importantly, it's the only case on the subject, that Article 22 may really prohibit automated decision-making. But of course, it does not prohibit human decision-making assisted by a machine. And the EU's AI Act makes AI systems concerned with the administration of justice, as again you'll all know, high-risk AI systems. And such AI systems are those, and I quote, intended to be used by a judicial authority or on their behalf to assist a judicial authority in researching and interpreting facts and the law and in applying the law to a concrete set of facts. But high-risk AI systems are not banned, but they must simply be closely monitored. And then we come to the most modern piece of regulation, the Council of Europe's Framework Convention on Artificial Intelligence and Human Rights, Democracy and the Rule of Law, which was adopted in Vilnius on the 5th of September, just a couple of months ago. It has aspirational contents. Those are epitomized by Article 4, that provides that states shall adopt measures to ensure that the activities within the life cycle of artificial intelligence systems are consistent with obligations to protect human rights, as enshrined in applicable international law and in its domestic law. This does not extend anyone's human rights in relation to automated decision-making. It is entirely aspirational, a very good thing, but aspirational nonetheless. The central point raised by all current regulatory techniques is whether it can really be sufficient if for most applications it's sufficient for the machine to advise and for the human notionally to decide based on the machine's advice. And I've considered whether the existing European Convention on Human Rights and its sister, the American Convention on Human Rights, are sufficient to provide the relevant protections for human decision-making in areas where that is necessary and appropriate. But for my part, I'm not sure Article 6 of the ECHR covers the situation, because even accepting that AI can introduce bias, we may well reach a stage where it will be demonstrable that AI decision-making is indeed fair and impartial, and maybe more reliable than human decision-making. Moreover, if the human makes the decision informed by AI, can it really be said that the tribunal is not independent and impartial? Probably not. And secondly, I'm not sure whether Article 8 of the ECHR covers the question, even if it can be construed as imaginatively as it was in the Verein Klima Senorian case in the ECHR. other articles in the European Convention, the American Convention, and the Charter probably come nowhere close. So it seems to me that the answer to the question I posed in this part of my talk is that the current legal and regulatory approach to AI may well not be fit for purpose. If, as I think we should be, we are concerned as humans to be the ones deciding what decisions are to be taken and advised upon by machines, and what decisions should not be, we will need to consider how that's to be achieved, both nationally and internationally. And what may be required is to ask the question of what additional rights, if any, humans should have to require business and governments to make transparent choices as to which decisions can and should be decided and advised by machines and which by humans. I'll come back to that in a moment. Let me move briefly to the second question. Is the current legal and regulatory approach to environmental protection fit for purpose? Now, it may be that the Switzerland and the Shell cases that I mentioned earlier demonstrate that in the current legal order, citizens can, in theory, at least call both government and big business to account in respect of actual or threatened environmental damage. But the problem here is that, as the Shell case shows, there's no clear delineation of what level of climate damage is permissible. And that was also made clear in my own judgment in the Court of Appeal in the case of the Friends of the Earth against the Secretary of State for International Trade and the Chancellor of the Exchequer. In that case, a couple of years ago, we decided that the government was only required to reach a tenable view as to whether its $1.15 billion investment in a liquefied natural gas project in Mozambique was aligned with the UK's obligations under the Paris Agreement. The government was not required to obtain a quantification of the indirect Scope 3 emissions caused by the project before making its investment decision. Moreover, the UK's obligations under the Paris Agreement, whose terms were not incorporated into English law, did not give rise to domestic legal obligations. Thus, whilst Article 2 of the Paris Agreement provides in effect that its 197 state parties should, and I quote, pursue efforts to limit the global temperature increase to 1.5 degrees above pre-industrial levels, it's hard to see how citizens can by themselves legally require big business and governments to adhere to that kind of international obligation. So, like the use of AI, it may be that there's not an easy regulatory solution. What may be required, here too at least, is to ask the question, even if we don't know the answer, of what additional rights, if any, humans should have to require business and governments to preserve the environment in which they live. So I come to the third part of the talk. What can or should be done to remedy these regulatory lacunae? Now, as I see it, and I've already said, the two problems are really connected. They are about the future roles of humans and human relations. They're also about the future relationships between humans on the one hand and businesses and their governments on the other. So let me summarize the two risks that I identify. And I see these risks as genuinely new. The first is the fact that AI will undoubtedly, in a relatively short time frame, be able to undertake complex tasks, including those involving varying elements of human empathy, with as much or more reliability than humans themselves. There's no unanimity about what rights individual humans have or should have against international businesses and governments to control the utilization of AI, to advise upon, or make decisions that were previously always advised upon and made by humans. The risk is that if nothing is done, AI will eventually decide or advise on the outcomes or even the most empathetic of human decisions affecting human lives. And the second risk is that if nothing is done, it will not be clear what rights humans have to require businesses and governments to preserve the environment in which they live. There is, of course, some unanimity, although not complete unanimity, that the lifestyle of the global north and its use of fossil fuels has caused the world environment to warm and therefore change. But there is no unanimity about what rights individual humans have or should have against international businesses and governments to control the nature and speed of that change. So both these questions are essentially existential, and they're not questions that can be resolved by any one country individually. As I suggested earlier, Switzerland alone, for example, achieving net zero will not solve climate change. AI is generally used in cross-border applications by multinational corporations. A solution adopted in one country is frankly unlikely to work without some international agreement. And there are, in addition, many skeptics who believe the problems are less acute than I've suggested, and many who think that they are more easily resolved. I don't claim to have the answers. My view is that it falls to the international legal community to consider these two questions carefully and to attempt at least to propose solutions that can be considered by national governments and international organizations. I return to what was said by that most impressive African speaker at the conference in Lausanne. He told us, as I said, to beware of assuming in the field of AI that the problems in Africa were the same as we diagnosed them to be in the first world. His concern about recolonization by AI may be something that could be said also by other parts of the global south. It indicates to me that we must be careful not to assume any unanimity of thinking without discussing these issues widely and carefully. And it's even clearer to me that there are very different approaches to climate change as between the global north and the global south. And again, these differences cannot be left out of account in the debate that I am suggesting. So if I'm right that existing regulations may not be sufficient to protect the rights of humans in the face of the growth of ever more capable machines and an ever more challenged environment, what are we to do? The first thing for lawyers to do, I think, is to identify the roles, responsibilities, and rights of humans that might fairly generally be agreed to need protection. For centuries, the UK has made a significant contribution to the identification of the rights of humans. One can point to Magna Carta, 1215, the Bill of Rights, 1688, the Representation of the People Act, 1832, and the UK's role in the formation of the ECHR. We've always had a clear understanding of the importance of individual freedoms and the rule of law. And this history might suggest that the UK could play a role in considering what legal protections are needed now to ensure that humans can still take essentially human decisions in the context of both AI and environmental change. It will be important in this connection not to make perfect solutions into the enemies of good solutions. One could perhaps envisage a more far-reaching rule along the lines of Article 22 of the GDPR, which said, as you remember, that you have a right not to be subject to a decision based solely on automated processing which produces legal effects. That can, however, still be circumvented, however more far-reaching it is, by allowing the machine to advise and the human to take a long list of scheduled decisions informed by the machine. To be effective, it seems to me that a new foundational right would need to be created. It would have to address what truly needs to be protected rather than the fringes of the problem. So let me take some examples. It would serve no practical purpose to require humans to consent to the use of automated decision-making, for example, because that consent could be obtained routinely, as it always is now, for cookies and the like. Likewise, a requirement to be informed in advance about automated decision-making doesn't really go far enough to solve the problem. It seems to me also that it is very hard to draw a simple line on the spectrum I mentioned earlier. It's hard to say when a decision does involve human empathy, and whether human empathy is the only area where we as humans would prefer to keep machines out of the loop. It might in theory be possible, for example, to have a fundamental right to have material human consideration of decisions requiring empathy or emotional intelligence. But that would immediately raise the question of which decisions require empathy or emotional intelligence. It might, though, start the debate. And I accept that even mechanical or mathematical decisions can involve, or at least cause, human emotions, or if only emotional reactions. For example, the injured pedestrian who is awarded less in damages by the machine than they thought they ought to receive might suffer annoyance and emotional trauma. Certainly many of the complex decisions that I identified in the middle of my spectrum might raise or involve some element, even a small element, of human empathy. The real difficulty is to identify where even AI-assisted decision-making infringes the fundamental rights of citizens as we might wish them to be. And that may involve, as a starting point, trying to identify the line where in the spectrum which is to be drawn. But even then, I'm afraid, there are many spectrums in legal decision-making and many more in every other conceivable sector of consumer, financial, and industrial activity. There are many possible examples, but I can see that many of the decisions to the left of my spectrum might reasonably not be said to involve human empathy, the pensions, benefits, for example. I can envisage, though, that neither tech corporations nor governments would welcome a restriction on their ability to streamline decision-making by the use of machines just because it involved an element of human empathy. And the environmental problem is even more difficult. There are already, I heard the other day, some 2,500 pieces of climate litigation going on in the world today. Claimants struggle to identify what precisely they're entitled to require governments and businesses to do to protect the environment. The solution here could be an additional individual right, but it could also be a more granular international treaty. Both seem to me to be very difficult to achieve, and particularly so in the light of the events at the recent COP29 summit. But as I said at the start, the fact that these two new problems are hard to solve is, in my view at least, not a reason for not trying. So let me conclude by drawing the threads together. My first conclusion is that existing forms of domestic, EU, and international regulation are probably not competent to prevent AI being used inappropriately to make decisions that ought, for the benefit of humanity, to be taken by humans. Secondly, the existing treaties and international conventions seem to provide individuals in different parts of the world with insufficient rights to impose limits on businesses and governments that are probably doing too little to prevent global environmental damage. It's obviously in the interests of humans to be able to limit environmental damage, just as it is in their interests to preserve appropriate human decision-making. The international legal community is uniquely well qualified to suggest solutions to both these problems. Such solutions will not emerge until the problems are identified as existential ones that affect essential human rights and the rule of law. And once that is achieved, the hard work will need to begin. It will be difficult to gain any form of consensus, but that is, as I say, not an excuse for not trying. So to conclude, as I started by asking, I do think it's right to say that AI and climate change are creating completely new situations that necessitate a rethink about the fundamental rights of humans. I hope I've provided you with a little food for thought. Thank you.